All right, I remembered to turn on the recording. We're way ahead of the game. All right, so we're here to talk about conduit clauses, changes, and claims. Sometimes I call it conduit clauses, changes, delays, and other claims, except that we're not really talking about delays, controlling delays, avoiding delays, working schedules. But a lot of what we are talking about will apply to a delay claim the same as it would for any other claim. I think all you guys know me, so I won't spend any time introducing myself. But we do a lot of work with changes and claims, and certainly that is an area that presents a need for legal work a lot of times. It's where disputes come from. And it is important to understand how to navigate those difficulties. Hopefully Rod's in okay now. Okay, there we go. All right, there's, our website, and this is chapter 5 in the book, incidentally. And actually, maybe I should do that right now. See if I can get this to suit. Nope. But if you go, oops, there it goes. And I'm screen sharing. So you should be looking at the book now. And if this is the Construction Law Survival Manual, you guys are familiar with that. We will be looking at a few appendices here, and I can share screen for that too. But one is a change order form, number 12, because I think when a PCO, a proposed change order, is a good form for a claim. We all know that change orders are rarely signed right when you present them, but it is good to present them in that form because they are complete. In other words, it is important to remember to make a proposed change order as complete as you can, make a claim as complete as you can. And we're in a few minutes, we'll be talking about the differences between a change order and a claim. So we'll also look at the general contractor lien and bond waiver. You could call it an owner lien and bond waiver also. One of the things we're going to talk about is the care you need to take to make sure you don't inadvertently give up your rights to changes and claims when you're signing a progress payment waiver. But I guess the main thing I wanted to show you is if you go to chapter 5 here, changes, delays, and other claims, that is, I'm pretty proud of that chapter, that it's one of the more complete chapters, and it contains everything we're going to talk about this morning and much more. We'll probably cover 25% of what's in 20 or 25% of what is in the book. Implied duties are a good example of something we won't be talking about because it's not directly related to claims, but those are very interesting. We will be talking about disputes a little bit, but not much, claim damages, etc. Okay, now, hopefully you were just looking at the book. I'm going to switch back to the PowerPoint. Now you should be looking at the PowerPoint. There's my email. Feel free to email me any further questions you have, name and address also. All right, so discussion of conduit clauses starts with the contract terms. Both of these sentences probably look familiar to you. You've seen them many times. They are in almost every contract you ever sign. Certainly if an owner or a GC is sending you a contract to sign, it will have a conduit or pass-through provision. As far as I am concerned, those terms are synonymous. And these two sentences we're looking at are synonymous. They're just different ways of wording the same concept. The provisions of the general contract are incorporated herein by reference. And one thing you need to understand, if you haven't already, is that that is a legalism, a legal term incorporated herein by reference. It doesn't sound very powerful, but it is. And it really means exactly what it says. The entire general contract, if this sentence is in your subcontract, the entire general contract is now a part of your subcontract, as if it was attached as an exhibit, as if all of those terms are in there. It's just like a similar concept I've told you guys, I think in the contracts lecture we did a few weeks ago, that, you know, when you send a proposal or a quote or a bid, you want to make sure you include at least one page of legal terms with that. You're going to do that, one, because the owner or the GC might just sign your proposal. That might end up being the contract. And if you have an opportunity to control the contract documents, you want to make use of that opportunity. Sometimes owners or GCs will just tell you to start. If the only document people have passed back and forth is your proposal, most judges will decide that was the agreement, that was the contract. But what I'm leading up to is that if they send you a subcontract, as they often will, you want to say right in the scope of work of that subcontract, you say the provisions of our proposal or bid dated such and such a date are incorporated herein by reference. And again, that makes your proposal and quote and any legal terms included in that proposal are now a part of the subcontract. And for the same reason, a GC is doing the same thing in the subcontract. The provisions of the general contract are incorporated herein by reference. I think the next sentence really means the same thing. Most subcontracts you see will probably say both. The subcontractor shall be bound to the general contractor to the same extent that the GC is bound to the owner. That seems outlandish to a lot of subs, particularly if you're not very experienced, but I have represented enough GCs, and I do represent a number of bigger GCs. I can tell you it makes perfect sense to me. That's the way it needs to be. That's the way it's supposed to be. A general contractor is a manager. They are a construction manager, and their job is to accurately carve that entire project up into a finite number of subcontracts and make sure that the entire scope of work is included within some subcontract or another. And then they manage the movement of all those subcontractors on the project to get the work done. And so it makes sense that if the objective is to carve the entire contract up, that the sub needs to be bound to the GC to the same extent the GC is bound to the owner. The hard part is, what you may want to say as a sub is, you might want to modify that to say you're bound to the GC to the same extent GC is bound to the owner, comma, with respect to the scope of work included within this subcontract. That's a change you could consider making, and I think it is reasonable, and GCs would usually agree with that. Okay, so item one, if you have a conduit clause, which I'm going to assume you always do, you need to get a copy of the general contract. There's no ifs, ands, or buts about that. You're entitled to a copy of the general contract. You must get it. That used to be a problem when I first started practicing law. I get the question in this seminar, well, what do I do if they won't give it to me? And the answer to that is go to their office. GCs used to always say, well, you can come to our office and look at it, but we're not going to send you a copy. And if that's what you hear, I am telling you, my advice to you is get on your horse, ride down to the GC's office and go in and look at it. First, if you actually appear, some nice receptionist person or somebody at that office will probably make you a copy and give it to you to get you the heck out of their office, if nothing else. I also want you to understand that you do not have to read the entire general contract. You probably need to skim all of it, what all you are looking for is the claims procedure and the dispute resolution procedure. The most important thing is the claims procedure. How much time, how do you provide notice of a delay claim? How do you provide notice that the scope is changing in some respect, where you're entitled to additional time or additional money, or you need additional instruction, or whatever it is? Because if you are bound to the general contract, you're worried about two claims procedures. You need to know what your subcontract says about claims, the deadline for claims, but you also need to know what the general contract says. And that's the main thing you're looking for in the general contract. It's not even one page. You can take careful notes on the exact procedure, not just the timing, but the form of your notice, where the notice goes. We're going to end up spending a fair amount of time talking about that this morning. Now, if the GC really will not give you the general contract, I advise you to request it in writing, especially if they won't even let you come to their office. Request it in writing, because when you end up in a dispute about a change order, one of the most common defenses you will face, one of the most common things you will hear is, you did not make your claim in accordance with the procedure in the general contract, and therefore you're not entitled to any extra time or extra money. And it's very important to be able to say, well, here are 6 emails where I asked you to give me a copy of the general contract so that I could comply with it. And you never sent it to me, and you refused to send it to me. And therefore we were unable to comply with the terms of the general contract. And I feel pretty comfortable in saying that pretty much every judge in the world would agree with that. So it's important to have evidence that you requested the general contract and did not receive it. Nowadays, in my experience, I would be interested in y'all's experience, but I find more and more of my clients, general contractor clients, they have all this stuff on a website. You know, they have the plans, the specs, the general contract, the schedule is all there. And I embrace that as a policy. That is what I advise my GC clients to do, because it is a team, it's a partnership to get this project done. And communication is key. Everybody needs to understand what they're supposed to be doing, and everybody needs to know what everybody else is doing. So I think that's less of a problem than it used to be. Getting a copy of the general contract, in any event, no ifs, ands, and buts about it. You must get it. All right. Your subcontract. will typically say there will be no payment for changes in the work unless ordered in assigned writing. First and foremost, I want you to understand that that is enforceable. That means what it says. A lot of unsophisticated or inexperienced subcontractors are pretty astounded by that. And even some of my GC clients, however, are surprised to find out that the Virginia Board of Contractors regulations, DPOR regulations, it is actually a violation of the standards of practice to perform any change order work without a signed change order. Explain that to me. How can that be? The DPOR can fine you for doing that. It can put your license in jeopardy. And I have to say, I've never seen that actually happen, but there's no question that's what the Board of Contractors regulations say. Why is that? What's the sense of any of this? What you have to understand, and what I have learned, is that one man's change is another man's clarification. And I like to give the example. I mean, I built the house I'm sitting in right now. I built the office where the law firm is. I built several things. And I walk on that site every day, and I'm walking around saying, hey, no, don't put that outlet there, move it over there. Or, no, change the color on that. Or, I'm walking around telling people what to do all day. I think I'm just instructing the contractors what is within the scope of their contract and what they are supposed to be doing. If that contractor thinks that this is a change in scope or a change in the schedule, they need to say so. And they need to say so in writing, because that notice may impact the owner's behavior. When you tell the owner, happy to do that, we will jump right on it, but I want to make sure you understand that's going to cost extra money because it's a change in scope. The owner may say, one thing he might say is, oh, okay, in that case, never mind, don't do that. Just go back to doing it the way you wanted. The other thing an owner might say is, oh, I disagree. That is within the scope. And you often end up in a posture there that you have to just agree to disagree and keep working on the project. But it would be important and it would be helpful to you to understand that there is, in fact, a dispute about whether this is a change in scope or not. I also want to emphasize that any change to the schedule is a change order requiring notice. There are two parts to, at least two parts, to every change order. One is the change in scope. The other is the impact on the schedule. In other words, I about once a year, I will have a client in my office, or nowadays it's always on the telephone, and they're saying, well, the owner won't pay me for all these changes. And I say, well, okay, what were the changes? And show me where you have signed change orders for any of this work. And they won't have signed change orders, and I have to tell them, you're wasting your time. Show me where, well, I'm getting ahead of myself, but show me where you gave the owner notice that you thought this was a change and you were going to have a claim for extra money or extra time. If you cannot show me that, I'll have to explain to you that you're wasting your time. You will stand no chance of recovering these funds. It doesn't matter that the owner told you to do that. Did you tell them clearly in writing that this is going to cost extra time and extra money. But the real point I'm trying to make now is that sometimes I will have a client in my office and the owner is asserting liquidated damages and the general contractor is asserting liquidated damages. And they say, Jim, I got this problem. I'm owed $200,000. I'm trying to collect. The project owner is assessing liquidated damages. The GC's spreading it around all the subcontractors. And I say, who? Well, was the project finished late? And you say, well, yes, it was, but that wasn't my fault. There was a whole lot of changes on the project. And I say, okay, good. Do you have signed change orders? And a client will sometimes say, yes, I have signed change orders. And I'm thinking, finally, we got a client that's got his stuff together. Everything's in order here. We're going to be able to resist these liquidated damages. Let me see those change orders. And this really happens all the time. They will have signed change orders, but they're absolutely silent about the impact on the schedule. There are at least two components to every change order. You got to explain the change in the scope. You got to explain the impact on the schedule. And if you don't put it in that change order, you are waiving that claim to additional time. The other point is you often have to do that in a defensive posture. If there is some sort of change that impacts only schedule and not the scope, you still got to follow the same claims procedure to provide notice of the delay in order to preserve your right for extra time. So if those LD claims come in at the end of the project, you have something to work with. You're giving me something to work with. Defensive time impact change orders is one way to phrase that. Okay, so problems in the field. We all understand how it is in real life, and believe me, I do understand. You want to avoid the hard conversation. Everybody's short on time. The owner's yelling at the GC, threatening delay damages, and this project's got to get done, and we're missing milestones. And the owner's always in a rush. The GC's always in a rush. You want to be cooperative. You want to help them. And having the hard conversation is well, number one, it's hard. It can get contentious and it takes time. But this is a really important juncture, I think, where I need to emphasize what you need to do and what you don't need to do. You do not need to get in an argument. There's no reason you have to have an argument about this. What matters is you provide written notice that this is going to cost extra money or it is going to impact the schedule. And yes, if this was a live seminar, somebody'd be asking right now whether an email is a writing, and the answer is yes. Email is a writing, same as a letter. A text message is a writing, although I really want to encourage you not to use text messages. I much prefer emails. I've had a horrible problem with texts. People lose their phones and then you have no record. It's not in any central database. If you use text, you need to download it all to your computer system. Whenever a client, all they have is text, I end up with pages and pages and pages of printed out of texts, and I got to scan them in, and it's difficult to run word searches and stuff. But if you just use email, and you can have email on a handheld, you're going to be able to word search through the emails. You're going to be able to separate them into separate projects, organize them much better, just like you would paper. Okay, you need to provide the notice. We did that. price is not the issue. And this is another big theme for today. To give you the big picture on that, we understand that you're not going to be able to finalize a change order in the hard conversation. You're not going to have time. The project cannot be delayed for that period of time. The owner isn't going to want to talk about it. We all know owners tend to pocket change orders. I rarely represent owners, so we can badmouth them today. The price is not the issue. Even the exact time impact is not the issue. You need to make it clear that this will cost extra money. This will delay the project. We will let you know the exact impact as soon as we are able. And you do need to do that as soon as you are able, but you don't necessarily have to do it in the initial notice. That varies from situation to situation. Change orders are never signed before.
That's my email
That
address.
moves you. Somebody needs to mute. John, is that you? If change orders are never signed before work is done, that moves you to the claims provisions in the contract. And I can tell you, well, there's usually claims provisions in your contract. There'll be a discussion of change orders that will say, you know, no change order work should be performed without a signed change order. That means what it says, I've told you, but that never happens. That moves you to the claims provisions that are usually in the contract that say, and we'll look at some examples later, but they say if an event occurs that you think will cost extra time or extra money, here's how you proceed. Here's the notice you have to give. But the other thing I want to make clear is that even if there are no claims provisions in your contract, act like there are. Just give written notice as soon as you can that this is going to impact the schedule. It's going to cost extra money. And every judge I have ever met will agree that that preserves your right to additional time and additional money. An owner has no absolute right to change the plans, change the specification, change the schedule without being responsible for extra charges. So become familiar with what claims provisions usually say and just comply with those notice requirements, whether they're actually in the contract or not. I think a PCO, a proposed change order, is adequate notice. I think that's a good form to put it in because it's a good checklist. It makes it very clear you're making a claim. Again, you want to make sure that you include the time component and the money. The claims procedures in the contract will say something like, you will give written notice of any claim within 48 hours of the event giving rise to the claim. That means what it says. Claims provisions usually discuss two things. Notice of the event, or these are my words. The contract may not use these words, but in my mind, there are two parts of a claim. One is notice of the event. This is what happened. The other is the quantification of the claim for time or money. Here's exactly how much extra it's going to cost you. Here's exactly how much of a time extension we're entitled to. I bring this up for a couple of reasons. One, my main mantra, what I keep saying over and over again, this notice of the event is the most important. That's what you cannot miss. If you miss that, you're losing your rights. We're happy to do, you told us today to do the following. We're happy to comply with that. We just want to make it clear that that is going to cost extra money and it is going to impact the schedule. Sometimes, and then just get the quantification to them as soon as you can, reasonably can. That is important. But every judge on the planet knows that sometimes you have no idea how long you're going to be delayed until you're complete with whatever the change was. And that's often true of the cost also, the material costs or whatever, until it's done. Now, the other reason I bring this up is sometimes contracts kind of put these two things together. I've read subcontracts where that say that in the event of any of, if there's an event that impacts the scope or the cost or the schedule, you have to give us notice before performing any work. You must include a complete time impact analysis. You must include a complete list of materials, in this initial notice of event. I have never met a judge that will enforce that because it makes common sense that is often just plain impossible. If it is possible, you would need to do it, but it is usually not possible. It is the notice of a judge will cut you slack on giving a complete quantification of time and money. They will not cut you slack if you fail to give notice of the event. All right, so you must follow the exact procedure in the contract. When to give notice, to whom to give notice is another factor. Sometimes the notice has to go to the GC only. Sometimes the GC and the owner. Sometimes your contract says you're not permitted to contact the owner under any circumstances. Other times it says you must give notice of any type of claim to both the GC and the owner within 48 hours of the event. Whatever it says, that's what you need to do. The claims procedures will also give you the form of the claim. And it's usually as simple as saying in writing, and it'll tell you what type of quantification you need, but we've already talked about the timing of that. Now, I think all you guys are subcontractors in any event. I want to make clear that you have to follow the lowest common denominator. Those are my words. The subcontractor, and you might be a sub where it's even worse, but a sub must follow the claims procedures in the subcontract and the general contract. You remember where we started, that's why you need a copy of that general contract. You need to know what it says, when to give notice, to whom to give notice, the form of the claim, and the quantification. You must put the GC in position to forward the claim to the owner in accordance with the general contract. What I mean by that, just to give you an example, let's say your subcontract says in the event of any excusable delay, you have to give notice within 5 days of the event giving rise to the delay. But then if you go look at the general contract, it says if there's any event causing delay, you got to give notice within 3 days instead of 5 to the owner. If that's what the subcontract and the general contract say, what is your deadline? 5 days or 3 days? It's 3, the lowest common denominator. You must put the GC in a position that they can forward the claim to the owner in accordance with the general contract. That is because of the conduit clause that incorporating the general contract by reference and saying you are bound to the GC to the same extent the GC is bound to the owner. You also have a problem with the pay if paid clause, which is usually in your subcontract also. If the GC is unable to collect for a change from the owner, they are not going to have an obligation to pay you. And that is a conversation I have had regularly, representing a general contractor or talking to a sub, or more likely their attorney. But you know, I hear them saying, yeah, but you told us to do this and it caused a delay, and or the owner issued this revised plans and specifications, and that caused a delay and it caused extra money. But my response might be, yes, but my general contract required me to give notice to the architect and to the owner within 3 days of the event, and you didn't get it to me until 10 days after the event. You put me in a position where it was impossible for me to collect for that change from the owner. And so now you're asking me to just come out of pocket for that money. That is not going to happen, Mr. Subcontractor. And we do, in fact, have a complete defense, and we will rely on it because we're not coming out of pocket to pay you for that. All right. Now, while we're on pay if paid or pay when paid, I do want to mention that's a whole subject in itself, pay if paid clauses, but it does play into claims for the reason we just discussed. I did want to at least explain the difference between a pay when paid and a pay if paid. They sound similar. There is an important difference. A pay when paid clause says something like the GC will pay the sub within 10 days of receipt of payment from the owner. That is how AIA contract documents read, an AIA subcontract. That's one of the reasons you kind of like AIA subcontracts. And you're usually willing to accept that form. It does not have a pay if paid. Back in the 1960s, 62, 63, there was a big federal case. It was a circuit court case, one layer below the Supreme Court, about a big federal contract of some type. But it was a dispute between a sub and a GC. And this is the way the contract read. The GC never got paid by the owner for whatever reason. And they said, well, that's a complete defense to the subcontractor's claim. The contract says I will pay the sub within 10 days of receipt of payment from the owner. I never received payment from the owner. Therefore, I have no obligation to pay the sub. The federal court decided in that case, no, if the parties intended receipt of payment to be a condition precedent to the GC's obligation to pay the sub, they could have said so. They didn't. This is just a timing clause. And if the GC never receives payment from the owner, the GC is still obligated to pay within a reasonable period of time. How long is a reasonable period of time? I don't know. That's one of the things I get paid to argue about. But I do know that if you finished this project a year ago and now we're standing in court arguing about it, a reasonable time has already passed. I mean, by the time you get to court, almost by definition, if you think about it, a reasonable time has passed and the GC now owes the money. So anyway, as soon as all the GC lawyers in the world read that federal case, they went rushing back to their office and revised all their subcontracts to use the words condition precedent. That's literally what the court said in the pay when paid case, that if the parties intended a condition precedent, they could have said so. And those are the words you usually use. It is an absolute condition precedent to GC's obligation to pay sub that GC receive payment from the owner. Those words do not have to be in it, the words condition precedent, but those words usually are in there. I can think of ways you could make it a condition precedent without using those words. For example, I've seen contracts that say the GC shall have absolutely no obligation to pay the sub unless and until the GC actually receives payment from the owner. The words condition precedent weren't in there, but a judge would probably conclude that those words did evidence an intent to create a condition precedent to the GC's obligation to pay. All right. That is a timing clause. Pay when paid is a timing clause. AIA documents contain that phraseology. Pay if paid, condition precedent, and that's what we call a pay if paid clause. This does shift the credit risk. If you have a pay if paid clause in your contract as a subcontractor, you are agreeing to finance the project. You are going to pay for completion of that project. You will be paid if and only if the owner remains solvent and the GC does in fact get paid. All right, now let's talk about some contract clauses. We're going to talk mostly about AIA documents, just because it's the single most common contract documents you will see in the industry. It's used less than half of the time, but I think it's still a fair statement that it's used more than any other single form. You like AIA documents as a general rule. We can agree, I would say it is definitely an owner-leaning document. And well, more above all else, it's an architect-leaning document because it's generated by the American Institute of Architects. But second, it is a owner-leaning document, but it is still much more even-handed and fairer than almost all proprietary forms in existence. Proprietary form is what I call a subcontract that's drafted by the general, the GC or the GC's lawyer. And I write subcontracts for a lot of GCs, and they are not as kind to you as the AIA document is, for sure. Okay, I think AIA documents are a good place to talk about nomenclature, what different terms mean. And that's really what we're going to get into now. Hold on, let's see, put it 8 total. Okay. A change order is based upon an agreement amongst the owner, contractor, and architect. Point being that you don't have a change order unless and until you have an agreement and it is signed. You might also have a construction change directive. Well, excuse me, let me back up. Under an AIA document, because it is an architect-oriented document, a change order must have agreement of the owner, contractor, and architect. Another form might just say agreement of the owner, but in this case, it's agreement of all three. A construction change directive, you only need an agreement between the owner and the architect that we will order this change. And we'll get back to those in a minute, change directives, but you're generally pretty happy to get those as a GC or as a sub, because it's clear that they're acknowledging that they're making a change. And it's usually clear that the change will require extra money and extra time. And the only thing left to argue about is the exact time extension and the exact money. That's a better situation than you'll usually end up in. In other words, it's like you've already given your notice of your claim. You don't have to give any further notice. The owner and architect are giving you the claim notice before you even start. There's also such a thing as a minor change in the AIA documents. That means no impact on time or schedule. If there is an impact on the schedule or the price, it is not a minor change. Okay, and if the owner and the contractor and the architect cannot agree on a change order, then it's not a change order. You use a construction change directive instead. In real life, neither one of those things are going to happen before you're ordered to do the work. We understand that will move you to the claims procedure. But again, I just want you to be familiar with the nomenclature and all the different possibilities. Upon receipt of a change directive, you shall promptly proceed. You must promptly proceed with the change. The change directive might have a method for determining the proposed adjustment in the sum or the contract time. All right. 15.1.3 is notice of claims. If you don't have either of those other things, if you don't have an agreement on the change and you don't have a change directive, that moves you to the claims procedure, which we're going to look at now. It is possible for an owner to have a claim too, also, but that's very unusual. Claims come from the contractor or subs below them. The claims shall be initiated by notice, and elsewhere in the contract, notice is defined as being in writing, delivered to a certain address or a certain person. And as we discussed earlier, you need to be aware of that, to whom the notice goes, the form of the notice, but you look elsewhere in the contract to get those answers. What this is telling you is that a claim starts with notice to the other party and to the initial decision maker, who is the architect, with a copy sent to the architect. Claims shall be initiated within 21 days after occurrence of the event giving rise to such claim, or within 21 days after you recognize the condition. Now, I underline 21 days, focus on that. That's a very generous deadline as far as I'm concerned. That's one reason you like the AIA document better than a lot of other ones. 21 days is a long time. But also notice in the following slides what happens to that 21-day time limit. If you have a claim, you shall continue to proceed diligently with performance of the contract, and the owner shall continue to make payments. This is telling you that you do not have to have a hard conversation. You do not have to have an argument. You do not have to involve your lawyer. You do not have to yell and scream. It is communication. You must provide written notice of the event. And you must continue performance. You cannot stop performing just because you're sure the owner isn't going to want to pay you, or just because the owner won't agree to the increase. You must continue performance. If, however, there is a claim for an increase in the contract sum, the notice shall be given before proceeding to execute the work. Okay? So if you think about that, the very next provision in this contract says, if you're making a claim for extra time, you'll give notice as provided in 15.1.3. We were looking at that just a moment ago. That said 21 days. So where you end up, and that might even be worth backing up if I can find the, nope, can't. Oops. There it is. Notice of claims shall be within 21 days after occurrence of the event. You'll give notice. So where you end up is if a claim for a time extension, you have 21 days after occurrence of the event, or after, it could be even later than that, when you became aware of the event. But if you are going to claim any additional cost, you must give notice prior to performing the work. That's an important deadline that I urge you to remember that will be enforced. You have to do it before you start work. All right, so here is an appendix out of the book that you can get on the website, and it's pretty simple, which is good. That's a good thing. So you may well want to modify it in some respect or another, but I like to use it just as a tool to explain how simple this is. This is a change order, an extra work order. But I encourage you to use a form like this for your notice, for your proposed change order. What is important is the big space, empty space here, where you're going to describe the work that you're going to perform that is different from the scope. And here you want to carefully explain why this is a change. What this is a change in this page, in this part of the plans and specifications. We will do this instead. So that's the hard part, and that's not a legal question. That's your job. Notice these default provisions down here. You have the choice of claiming you will do this change work for a fixed sum, a fixed fee. You could just say so much per hour for labor, plus 115% of the cost of all materials. You can just say actual cost plus 15%. But notice even beyond that, if no precise method of adjustment has been determined, then the contract sum shall be equitably adjusted at contractor's standard rates, and the time for completion shall be increased by a reasonable time, an equitable amount of time, if no time estimate is presently agreed. So in other words, you have the opportunity to identify an exact dollar amount and an exact schedule, but the default provisions say that the scope, the budget and the schedule will be adjusted equitably based on this change that you have carefully described up here. And that's you've done everything you need to at the claims stage. So you want your field people to have forms like this around. And if they're just using email, which is okay, make sure that language like this is included. You know, set them up on their handheld with this form that they can email. All right, in the field, I encourage regular status letters and emails. I think it's fair to say that GCs really like receiving that. Owners really like receiving that. Here's what we accomplished this week, and here's what we intend to accomplish next week. Here's where we appear to be on schedule. We need selections from the owner on the following items, and this we will soon be delayed from performing portions of the contract if we don't have that. We're still awaiting delivery of materials is a big thing right now with the pandemic. Supply chain delivery delays is a big part of what we're dealing with. It's important to provide updates on that. It's also very important to anticipate where the delays are going to be and to do everything that you can to make up for the delay or find other sources or whatever it is, and report on that in a weekly status letter. And this is, I think that's good. That's communication. That's not starting arguments. It is actually helpful, helps get the project done, and it may preserve your right to claims. It's a good place to protect your right to extra time or extra money as a substitute for a claim, or as a type of claim, is a better way to put it. All right. Make sure you explain pending changes in scope or schedule. Be sure to warn about possible future owner caused delays, instructions and selections needed. All right. In delays, I'm really repeating myself, but that's because this is so important. There's a difference. There's a difference between an extension and an increase in the dollar amount of the contract, but don't forget that you got to worry about both of them. Even if you have no claim for extra money, make sure you give notice of any event delaying you as a defense to possible LD claims later. The delay must be excusable. We're not going to get into delays with any great detail, but as a general rule, the delay must be excusable, must be unforeseeable. Changes in scope are clearly excusable delays. In a change in scope, you must still give notice of the delay. Make sure you do that in any proposed change order or notice of a claim. Weather is kind of a special case. It must be beyond normal when you're talking about delays. And you guys are experienced enough that you understand this probably, but I sometimes get less experienced clients who are, the owner's claiming delay, and I ask them, was the project finished late? And they say, well, sure, but it rained a bunch, and, I'm like, well, this is Northern Virginia. How long have you lived in Northern Virginia? It rains a lot in March and April and May, and that's normal. And you have the burden, client. You got to prove that on average over the last century, here's how many days it has rained in March and April in Northern Virginia historically, and here's how many days it rained in this March, and it was twice as many days, which you're not going to be able to show. The weather, so this is another way of saying it must be unforeseeable. Weather delays are quite foreseeable. And weather delays particularly, just be aware that you got to prove that the weather was well beyond normal. All right, so let's talk about, this is coming out of, there's another lecture I do on reviewing and revising construction contracts. Just pull a few pieces out of that. We know that when you receive your subcontract, the reality is you're not going to be able to change that much. The GC is going to insist on you using their subcontract form. Therefore, you're looking for the 5 greatest hits, things that are most likely to cause real life problems, things that you can get the GC to change, and things that you can change with a small number of words. And I'll give you a few examples of that. The single most important, and this is really a protection for claims against you rather than not so much protection of a claim you might have against the GC or the owner, but your subcontract might say, if subcontractor breaches any provision of this contract, then GC or owner may declare this contract in default and terminate this contract on written notice to seller. My question to you is, when you receive this notice described at the end of this sentence, what are your opportunities? What should you do about that? The answer is nothing. There's nothing you can do. This notice terminated you. When you receive this notice, you're already terminated and you no longer have a contract. You need to have notice and an opportunity to cure. So you take your pen, you put a line up here, put a line out to the margin, put a line down the side, and you put the words in yellow right up the margin of the contract. So now it says, if seller breaches any provision of this contract and subcontractor does not begin to diligently cure such breach within 10 days after receiving written notice specifying the breach, now buyer can declare the contract in default and terminate the contract. What you've done is changed the definition of default. Here, any breach, you're in default and can be terminated. Here, any breach, you are not in default unless you are provided written notice, not just notice, but written notice. Not just written notice, but the written notice must specify the breach. And you're not in breach unless you fail to diligently begin cure within 10 days after receiving that notice. Now, this protects you. If you end up in a dispute, 6 months later when you're in court, you're going to receive a list of 35 different things that you did wrong on the project and all the damages that were incurred as a result. You've protected your ability to say, wait a minute, Judge, this is the first we've heard of that. When this event occurred, all they notified us is that of one problem. And so we're responsible for damage only on that one problem and not on all this other stuff that we're hearing for the first time. And a judge will enforce that. Now, unilateral attorney's fee provision is another example. This is what we call a unilateral attorney's fee provision. If sub breaches, sub shall be responsible for all of the owner or GC's attorney's fees. This is not bilateral. It does not work both ways. The owner, the sub could not make the owner pay attorney's fees. the owner can make the sub pay attorney's fees. Now, people will agree to change this. If you're having any difficulty, it's just like the earlier one. If they didn't give you notice and an opportunity to cure, the best way to deal with that is to say, now, wait a second, you're telling me that if I do anything wrong on this project, you're going to terminate me immediately, and that'll be the first I hear about it. You won't give me notice. You won't tell me to come out and fix it. And people will always say, oh, no, I'm always going to give you notice. I'll send you multiple notices to get you out there. And then you're able to say, well, great, let's just say that in the contract. You know, if there is a breach, you'll give us notice. We've got 10 days to start cure. This is the same way. You can say, wait a minute, if I do anything wrong in this project, I got to pay all your legal fees, but you can just blow me off and not pay me for 6 or 9 months, and I got to sue you. And if that happens, you're not going to pay any of my legal fees. And it's just a patently unfair situation. People will typically agree to changing a unilateral attorney's fee provision to a bilateral provision. Notice that all we're doing is striking out 1, 2, 3, 4 words and adding 3 words. You're not muddying up the entire contract. People will agree to that. So or you can just add a bilateral attorney's fee provision. Just write this sentence in the margin at the bottom, somewhere, anywhere on the document. It's not that hard to fit. So that's the sort of thing you're looking for when you're revising a subcontract that's sent to you. Things that make a big difference that you can change with just a couple of words. I explain those things just as a warm up. Hopefully you found it helpful, because that's what you need to do with waivers, progress payment waivers, and you also need to do with your subcontract, the claims provisions or the timing provisions, which we're going to get to in a moment. But waivers, if you receive you're about to get a progress payment, and the waiver you receive states something like what's shown on the screen. Are you ready to sign this waiver? If you fill in the correct dollar amount that you're going to receive, are you ready to sign this with today's date in it? No, I think this has real problems. What about retention? This says, in exchange for this dollar amount I'm receiving today, I waive, release, and quit claim any right to any lien for labor and materials supplied through today. Right? Isn't that a problem? Retention is for labor and materials supplied through today. You just waived your lien and bond rights for your retention. What about change orders, which is the real point of this seminar, because we're talking about claims? You just waived your lien and bond rights for any pending change orders. And we know that the owner is going to shove any change order claims. They always get shoved to the end of the project. And that's what everybody wants to talk about when they're finishing the project out and closing it out. And it could be a year or 2 after you actually perform the work. Well, if you sign this waiver, you waived your lien and bond rights for retention or any of those change orders. And believe me, that can be a problem. The other thing you got to watch out for is you don't want to say labor and materials supplied through today. If you're only being paid through 31st of January 2020, what work is included in the last requisition you sent? You got to make sure that date is correct. and you want to say except for funds held for retention and change orders. Not changing very many words. You can get people to agree to this. It helps quite a bit. Now, this waiver, this is in, if you look in the book, I give an example of a waiver that a sub wants to sign, and I give an example of a waiver that a GC wants to sign. This is out of the GC waiver form, and you may face waivers like this regularly. In exchange for receipt of X number of dollars was in paragraph 1. Sub-supplier does release the owner, the tenant, the GC, the surety, the bonding company, whoever's going to buy the property, and the project from any and all causes of action, suits, debts, liens, which you ever had, now have, or will ever have against the owner, leasehold owner, etc. That is a very complete waiver, but I want you to focus on two things in particular. Parts of it are just like the lien and bond waiver, whether you're waiving lien and bond rights for materials supplied through today, but this is also waiving any and all types of claims, all causes of action, suits, debts, liens, bond claims, everything. So in other words, I want you to have some recognition of the difference. You might be waiving just lien rights, or you could, in a progress payment waiver, could be waiving any claim of any type. You're giving up your rights to claims. All right, I'm smart enough to change this screen. Hold on. Okay, you should be looking at the GC waiver and release now. Paragraph 1, like I was saying a minute ago, that gives the dollar amount. Paragraph 2 is the one we were just looking at the close-up of. In exchange for that dollar amount, you give up any and all claims that you have. And then the rest of it's not consequential to what we're talking about today. Hold on, let's see. Okay, there we go. So how do you deal with this? And if I'm representing the owner of the GC, I am definitely trying to get you to sign this waiver. You as a sub or as representing a sub have to notice it and have to do something about changing it. What's reasonable, what isn't? Progress payment waivers, there's no question a GC or an owner need waivers in exchange for a payment for the sub. One issue is, am I waiving my lien and bond rights for the check you haven't given me yet? Or only for the prior requisitions? I think in real life, even if a waiver says the receipt of which is hereby acknowledged, the law will protect you. If you never receive the check, I have some confidence a court would rule that there was a complete failure of consideration. And I have had courts rule that in my case. My client signed this waiver but never received the check. You still have lien rights. There was a failure of consideration. So it's better to cross out receipt of which is hereby acknowledged. It's better to say upon receipt and clearance of funds, comma, but that is a battle that may not be worth fighting if you have trouble with it, because I think you have a failure of consideration. However, they are entitled to a waiver, but a lot of waivers say, and a lot of contracts say, you have to give me a waiver for all payments prior to this one I'm going to give you now. That's perfectly reasonable. If you're waiving your rights for the payment they're just handing you tomorrow, you want to say upon receipt and clearance of funds, they are also going to want waivers from all of your subs and suppliers. Again, reasonable, but it's usually going to be one requisition behind for all prior requisitions or for all labor and materials provided through this day. That's one issue that you have. But I think in real life, you're only waiving your rights for prior requisition, no matter what the waiver says. What if you as a sub cross out, I'm waiving lien rights I may hereafter have? I think that's an acceptable change. I think a sub has to see that and do that. This isn't a lien and bond waiver, but seminar we're doing, but I think that's an acceptable change. And I will tell owners and GCs that the waiving rights that I now or hereafter have is not reasonable, and you do need to agree to change that. You have to agree to let them change except for retention. You have to let them change waiving rights for labor and materials supplied through today, and let them add an effective date, whatever date this requisition is for. That's an acceptable change. But what if you revise a waiver to say, except for change orders, as I've advised you to do? That's what I think you want to do. That's a little bit trickier. And this is really the point I wanted to make. I tell my GC and owner clients that if the creditor, if the sub or the GC wants to add except for change orders on, or except for claims on a lien waiver or a claim waiver, you've got to make the contractor list the date, dollar amount, and change order number of all change orders they're talking about. In other words, don't ever let a sub or a contractor that you're going to pay, don't ever let them say, comma, except for change orders or other claims. You say, okay, well, now's the time you got to give me a complete reconciliation of all change orders you have claimed, and tell me the dollar amount, and then I will let you accept them from the release. But I'm not going to just let you say any and all claims. You can tell them, I'll tell owners or GCs, you can only accept claims that you have actually submitted. And I have recognized that you have submitted this change order. There is a change order number and a change claim date. To add only the extent of payments, you as a contractor, you would like to add words saying this waiver is effective only to the extent of payments actually received. Is this an acceptable change? I think the hang up here is the same as we just discussed, only to the extent of payments actually received, but this limitation is effective only with respect to the following change orders or claims that are listed. Okay. Final waivers are a very different situation. And some people need to hear this. If you are really receiving final payment, if they're about to give you final payment and you never expect to receive another dollar off of this project, then you don't care how the waiver reads. You should review it and make sure you're not conveying your home or your vacation home in it. But generally, you don't care how the waiver is worded if you know you're done. It is a final waiver. All right, now we're moving to a few new topics. One is concealed conditions or differing conditions. This is the cause of claims on many contracts, and a demolition contractor would have particular concerns with this because you have no idea what's behind the walls until you start tearing them down, and there may be hazardous material or whatever it is. Point number one is the contractor bears the risk of concealed conditions unless the contract says otherwise. And I want to make sure you guys understand that. If your contract just says, I'm going to build a building meeting these certain specifications, I'm going to excavate and build a foundation and build this house, and it doesn't say anything about rock or other concealed conditions, it doesn't matter how much rock is under the ground. The contractor needs to pay to remove it and needs to provide that finished product at that fixed price. Now, that is the law. And as a result, if an owner does not agree to a concealed conditions or differing site conditions clause, then all of the contractors in the world are going to put a huge contingency on every contract they ever do because of the chance that there will be rock or some other concealed condition that they're not aware of now. Just because it might be there, they got to protect themselves by putting in money for rock that may or may not be there. So the industry as a whole, all the owners of the world, the American Institute of Architects, AGC, the entire industry has agreed that all the owners in the world would rather have a differing or concealed conditions provisions in their contract so that contractors do not have to put contingencies in their contract sum for that. And owners only have to pay for the rock if there is in fact rock there. But there are often, well, always, notice there are provisions just like any other change in scope, the form of the notice, to whom notice goes, and what the deadline is. And notice under the AIA documents, it is within 14 days after you first observe the condition. That's a pretty generous deadline. Not quite 21 days like for a delay deadline, but it's pretty generous. Actually, I don't really understand why it's such a long deadline. You would think a concealed condition, you could easily make it 72 hours, but the AIA documents do say 14 days. All right, so notice this did discuss type 1 and type 2. Encounters conditions at the site that either, number one, subsurface or otherwise concealed conditions that differ materially from what's in the contract documents, or two, this is a different type, unknown physical conditions of an unusual nature that differ materially from those ordinarily found to exist. All right, so type 1 has to differ from the contract documents. It has to be a concealed condition that's different than the contract documents. So that could be a defect in the plans or a misrepresentation of conditions on the site or an error of some type. Type 2 does not depend on what's in the plans, doesn't have anything to do with that, but it has to be unknown, and it has to be physical. So it's not a weather issue, it's not labor delays. It has to be unusual, has to be physical, and it has to be unknown. And that's the more often, type 1 is much more common than type 2. And the main debate you end up in there is, can a disclaimer protect the owner? Because the battle you end up being in is they give you a bunch of soil borings before you're bidding or as you're bidding, but then they want to say, well, you're not allowed to rely on these. But then they're going to say you knew there might be rock. That's where the arguments end up being. You also have to notice the site investigation provisions in your contract. I was reviewing a contract earlier today that this was essentially what it said. Actually, it might have read exactly like this. You are usually agreeing, the contractor, that you're fully qualified, you have investigated the conditions involved in performing the work, you have investigated the quality and quantity of surface and subsurface water, the character and extent of existing work adjacent to, uncertainties of weather or physical conditions of the site. So you need to be careful with this. You don't want to agree that you have ascertained all of the conditions involved in performing the work. I think this language in a contract is troublesome. You would rather have it read, this is the way an AIA document reads, you have visited the site, you're okay with that, you're generally familiar with local conditions, and you have looked at the contract documents and the work to be performed, and it makes sense in my observation and in my experience, this makes sense. That's a lot different than a provision. Sometimes they say you warrant, contractor warrants to the owner that the plans and specifications are correct. I mean, that's crazy. You can't agree to that. The AIA document says affirmatively, these obligations are for the purpose of facilitating coordination, and the owner, they're not for, the contractor doesn't have the burden of discovering errors, omissions, or inconsistency in the contract documents. However, if we see any, we will promptly let you know. This is okay. And in fact, the underlined language here is exactly what you'd want to add to the prior site investigation provision that we were looking at a moment ago. The obligations to go out to the site and to inspect it do not give us the burden of finding all errors, omissions, or inconsistencies, but if we see any, we'll let you know right away. The contractor, this is again what the AIA document says, contractor is not required to ascertain that the contract documents are in accordance with the code. That's very different. Sometimes contracts go so far as to say, you as the contractor warrant to the owner that the plans and specifications are correct. You don't want to agree to that. Force majeure. This is a force majeure clause, what is in red. Seller is not responsible for delays caused by conditions beyond your control. Again, the first thing I want to make clear is that you are responsible for delays caused by conditions beyond your control unless your contract says otherwise. So in other words, you must make sure that your contract has a force majeure clause. Otherwise, if you sign a contract that just says, I promise to build the following described structure to the following plans and specs and will complete by, whatever date, if the project's not complete on that date, it's your fault and you are liable for damages. It doesn't matter what the weather was. It doesn't matter what war started. It doesn't matter what pandemic occurred. It is the contractor's problem. So again, you must make sure that there is a force majeure clause in your contract somewhere saying you are not responsible for delays beyond our control. And that's all it takes is that one sentence. Add it in there somewhere. You can get people to agree to it. Here, now I'd like to talk about the current battleground. The new battleground, I can remember when pay if paid clauses were a new battleground and people tried to change them and it isn't going to work. You're not going to be able to change them. This is the battleground today, in my experience. Contracts will often say something like this. Owner or GC may require changes in the time periods or durations or sequences of the work involved. Let me translate that for you. What that says is, I'll let you know what the schedule is when I'm good and ready to let you know what the schedule is. And if you don't keep up to it, you're in breach of contract. I do not think you can agree to that. You must see this, you must change it. It's like the difference between a unilateral attorney's fee provision and a bilateral. It's like not having notice and an opportunity to cure. It's like not having a force majeure clause. You cannot agree to this. How do you change it? With as, have effective changes with as few number of words as possible that you can get people to agree to. You use the words reasonable and you use the words by mutual agreement. Here's another example of the same thing. This is a little more detail and that makes it even worse. You're liable if the owner or the GC changes the schedule, including amendments, even if they differ from the schedule attached to your contract. You are in breach of contract. We'll let you know what the schedule is when we're good and ready to. Now, at the end, it says time is of the essence. Is that a problem? The main reason I put that in this slide is to make it clear that that is okay with you. You don't mind agreeing that time is of the essence. All that means is time matters. We care about the schedule. And of course you care about the schedule. Everybody does. The owner does, the GC does. And you're okay with agreeing time is of the essence. What you have a problem with is the owner or GC's unilateral right to amend the schedule. You cannot agree to that. Here's how you change it. You put your pen here, you put the line out here, and in the margin, you write the word reasonably. So it says, as reasonably amended. Even better to say, as amended by mutual agreement. Agreement is necessary for any change to the schedule. Both of those are reasonable changes. What does reasonable mean? Isn't that a vague term? Well, yes, it absolutely is. But I remember the lawyer that hired me right out of law school telling me that all you need to do is give the judge a hook to hang his hat on. And I think that's true. If you made no change at all a judge would have a very hard time dealing with this contract provision because you agreed to keep to the schedule, even if it changed, even if it was different from what was in your contract, you're going to be liable for that schedule. You're a grown-up, you're an experienced business person, you agreed to it, you're going to have to live with it. But if you could get the owner of the GC to agree to just the word reasonable, it gives the judge an opportunity to say, well, yeah, but that's just not a reasonable change. And it really will help you. That one word really will help you if you end up in this argument. By mutual agreement is even better. Adding a force majeure clause is even better again. So if you can get those three changes, that would be what you're trying to do. Here's another example. I guess let me back it up once. Time is of the essence. We don't have a problem with that. That's the notice, and complete your work in accordance with the schedule as established and amended from time to time. You want to make it clear that you mean reasonable amendments by mutual agreement, and you add your force majeure clause if you can. So you got to be careful with schedules. Generally, you would rather have a set start date and a finish date. Nowadays, you usually have to agree to a starting on a notice to proceed. You usually have to agree to that. And it's okay. It might mean you don't have much notice when to start, but a GC worth their salt is going to give you warning because they're going to have the same problem you do. They got to get started. But that can be a problem in a job that's not well managed. You as a contractor, whatever the start date is, notice to proceed or otherwise, you would like to make sure you have 140 days of unimpeded access to the site to complete your work after the notice to proceed. That's the phraseology you want if you can get it. You cannot agree to an unknown schedule. You cannot agree to modifications to the schedule without agreement. Only reasonable modifications. All right, to reiterate or conclude on delays, you have to give notice for a time extension. You have to give notice for dollar increases. You must give notice of the event to get a time extension. And you need that to get relief from LDs. The delay must be excusable. It must be unforeseeable. Changes in scope, you must include notice of delay in any change of scope. All right, liquidated damages clauses are generally enforceable. That was 50. The parties can agree that if it is difficult to prove your actual damages, we can agree in advance you're going to pay $150 a day liquidated damages or $5,000 a day in liquidated damages, but only if it is difficult to prove your actual damages, which it normally is. So you have to give notice of time extensions to protect yourself against LDs. LDs can be a penalty if they're much, much more than actual damage. But again, saying that assumes that it's possible to prove your damages, and LDs will be permissible if it is impossible to prove your damages. It cannot be a penalty. I do want to make the point that LDs are a double-edged sword for you as a sub. you generally are afraid of LDs, or I found clients are afraid of LDs, getting charged with LDs, but it can actually be good news because the owner's damages might be higher. And the owner and the GC are limited to the agreed daily rate, even if they suffered much more damage than that. So in other words, don't view LDs as bad always. LDs might be your best friend. The question is, what is the dollar amount, the per day dollar amount? And is it high, or could damages be higher than that? It's a way to limit damages. The other thing about LDs is that you cannot claim LDs. An owner or a GC cannot claim LDs if they are responsible for part of the delay. That's the general rule. Although one argument you get in is the extent to which they can avoid this in the way the contract is written. So it is often possible. I mean, usually the GC or the owner is responsible for part of the delays, and therefore usually you have a defense to LDs for that reason. And the same thing between a GC and a sub. It's even more true that a GC is responsible for some of the delay, and that's a big issue for GCs. It's a good defense that you have because you're usually going to have GCs will usually just try to shove LDs down to their subs. Subs are usually going to have defenses because the GC is at least partially responsible for those delays. No damage for delay clauses are generally enforceable. And so as a seller of labor and materials, you want that in your contract if you can get it. Yeah. All right, so there's your extra change order work. That pretty much brings us to the end of the topics I wanted to discuss. Do we have any questions? You guys can all unmute yourselves now, and it'd be good to ask one question at a time if you can, but you're welcome to ask any questions that you want. Chris.
We've got a GC, only one out of a large number of GCs we work for, that has been impossible in terms of giving us a copy of the prime.
Yeah.
And I'm just, I've been pulling my hair out for years. I mean, I'm at the point where I don't want to work for them because I also have, it just appears to be an unreasonable GC. Do you have any words of wisdom on that?
Yeah, I tried to address that earlier, although I don't blame you for thinking it was incomplete, because to some extent that's an unsolvable problem. If the only way to solve it is just never work for that GC, which is problematic also. I can tell you the most important thing to do if you want to work for that GC, if it's profitable work, whatever. The most important thing to do is send them emails, send them writings. I need a copy of the general contract. The subcontract you sent me requires me to comply with the general contract. I can't do that if I don't know what the general contract says. I mean, I would literally say this in the email that you send to them. And I think every judge on the planet, if a year later, a GC is trying to hold you to the terms of a general contract based on a conduit clause, and you could show where you pleaded with the GC for a copy so that you could comply with the general contract and you never got it, no judge is going to enforce that. And that's why I think it's so important to ask for the general contract in writing if they refuse to do it.
I thought they were so unreasonable. They make you drive to their office, which
Yeah.
is about a 2-hour drive, don't give you any parking,
Yeah.
and then sit you in a conference room with about 3 people, and they say, well, do you have any questions? And I'm like, I'm going to be here a while. If you're going to babysit me, the 3 of you, for
Yep.
3 hours while I go through this thing, and they're worried about me taking pictures of their, I mean, it's just unbelievable.
Well, it is unbelievable. I agree with you. It's unreasonable, but I think you dealt with that exactly the correct way, Chris. Number one, I don't care if it takes 2 hours. Just figure it as part of your cost. That's part of the cost you're going to have with every job you do with this GC.
Yeah.
And get on your horse, do the 2-hour drive, and then do exactly what you just described. Look them right in the face and say, I'm going to be here a while. You know, if give me a copy of this general contract, I will leave in 5 minutes. That would be one way we could deal with this, or we will be here 3 hours. Your choice. I don't care.
And they left me there 3 hours. But you know what? I
they
learned
did.
something in those 3 hours. I
Yeah,
learned
what'd
what
you-
they do to subs. They eat them for breakfast.
Yep. Yep. I hear you. So who's even in here anymore? How do you get a list? Oh, there you go. Oh, Rod is here. You there, Rod?
I sure am, Jim. I just had to figure out how to unmute myself.
Right. I hear you. You got any pearls of wisdom to give us?
I think if you're looking for wisdom, you've come to the wrong place.
Come to the wrong place. How about you, Alex? You got any pearls of wisdom? Jimmy Worrell. I didn't even know I was going to do that. Oh, here's a good one. Here, we'll jump back to this in the last couple of minutes. Sorry. The AIA document has this term I've put up above here, that you're allowed to ask for verification of financing. This is a really important provision in a contract. A lot of people are surprised to learn that this is in an AIA document. It's right in your subcontract if you have an AIA subcontract form, and it's very important that you have no obligation to commence work until the owner provides such evidence. Evidence of financing for the project. You can ask the owner, show me you got the money to pay for this project. The GC can ask the owner that, and you can ask the GC for that evidence. Now, that becomes particularly important if there are delays or if there are changes. Changes are a sign of problem. You might think, oh, you know, that's a high profit work that I didn't have to bid. And there's some truth to that. You can make a lot of money in change orders. But I guess my point, I'm trying to get you to realize it's also an alarm bell. Something's wrong. Nobody has changes on a project on purpose. They're always a mistake of some type. And what I'm trying to emphasize now is that you, as a creditor, before you supply labor and materials on a project that has been delayed or on a project that have had changes in scope, you may want to ask the question, owner, do you have the money to pay for this change? The budget on this project has just gone from $10 million to $11 million. do you have that extra $1 million, owner? Really important question to ask. And that's what this number 3 says. This has been watered down a little bit. The 1997 form, you were allowed to ask for that evidence at any point. And 2007 form was watered down a little bit. I forgot the exact wording, but starting 2017, you can always ask for evidence before you begin work. And that's something you want to do. It depends on what the project is. It depends on who the owner is. But I represent a GC on a lot of Amazon data center projects. And I'm telling you, they always ask for evidence of financing before each of those $80 million projects start. I mean, it's a reasonable question. But after the project begins, they have to give you evidence only if 1, 2, or 3. The one I want to emphasize is 3, a change in the work materially changes the contract sum. Make sure you make use of that. But also you can request evidence if you have a reasonable concern regarding the owner's ability to make payment. So if you see something in the field, or it could even be rumors on the street, or, that's a little harder to, you could end up in arguments about whether you have a reasonable concern. It's harder for them to argue about a change. If 3 months have just been added to the schedule, that is a change that's going to impact budget, and you want to ask about it. Okay, that's all I got. Any other questions from anybody else? I thank all of you for attending. Everybody stayed all the way through. That's amazing. Screen.
Hey, Jim.
And hey,
This is Michelle Mucka. I just had one little question. When you were talking about the unknown physical conditions,
yeah.
and you were talking about the rock, but are there any other examples you could give?
Oh, stuff behind walls is the other one that's real common. That would be
Okay.
applicable in the case of any renovation or it's a everyday problem. If you're building additions or renovations, what you're talking about is asbestos insulation. That's, you don't know what's behind that drywall until you tear that wall down. There could be infestations, there can be water damage, whatever. In site work with rock is the most common. What company are you with, Michelle?
I'm with Valley Lighting.
Okay.
I think you know Bob Olshaw.
I sure do. And yes, I recognize the name Michelle Muka, but you weren't on my list here, so I wasn't sure what.
Right. I got the email and just decided to listen to it today. So
Well, that's why I sent you the email. So thank you for coming.
thank you, Jim.
That's why Chris came too. He never signs up either, but he shows up.
Okay, thank you.
All right, guys. So I'm signing off. We're right on time, 11 o'clock, 2 hours. And so August 26th, we're doing disadvantaged business enterprises. And hopefully you guys can make that. It's commercially useful function, and doing business with disadvantaged business enterprises is what's that's about. Not how to become a DBE, not about how to get DBE work, which are important questions, but it's not what it's about. You're required to do business through a disadvantaged business enterprise because the owner needs to comply with DBE participation requirements. There's a lot of tricks to protecting yourself in that way. So we'll see you then, August 26th. And then we're starting live seminars in September, about one a month, September, October, November, and December. We're starting live ones, and I'm curious to see how many folks show up for that, but I'm looking forward to doing that, and I hope some of you guys can make it. All right. Thank you again, and we'll see you soon.
Thank you, Jim.
Thanks much.